Attorney General Ora Dame Oko CID with the issues of Jakpa complaint or the Ekoye, and then the other one has to do with a wound to me at the end. Who come on and about this is Siana Fee, who can ever fast one. You bet me solve our problem, and I see who solutions are a woman more now. Ya share the echo any dear Balaya matching Bibia Boko there.
Everything is fine here.
Now me can't say me come match here. Now I just say oh yeah nia Bibia Boko. Uchi no lawyer still out. Matthias here. So let's start with the issue of former Attorney General Dame and the CID and Jakpa's issue. Now Odami tells us that Jakpa's complaint is baseless. I mean, we're talking about the issue that has to do with the $2 million ambulance case. A fresh one that has come is that the CID has invited Odame, as in Godfred, Odame to come on some issues that Jakpa had raised with the CID. But I want to ask first off, if issues of this nature is settled in court, can someone also raise the same issue again in connection with the same issue that has been dealt with by the court to CID to say we should now come back again, look at some of the things that really went wrong? Is it proper?
Absolutely, yes, because what might have been dealt with in court is legal. Again, you know, what the complaint against the former Attorney General is in two folds.
Okay.
We also have the ethical part of it.
Okay.
You know, even somebody can even also go to General Legal Counsel for him to be interrogated, because it is ethically wrong by our profession for you as an opposing or a counsel on the other side to interfere with a witness. So even as the matter might have been dealt with in court, ethically some people can also raise issues. And so for me, I don't think the matter is done with a lot. If it can be established that indeed he has an interaction with the witness of the accused person in a manner that sought to say that he is trying to coerce or teach, coach, show the person how he should conduct himself in court, that tells you that then it means that the judiciary, or what we ought to have as justice in the court of competent jurisdiction, is not seen. Because everybody goes to court to get justice. And justice must emanate from free and fair processes. Where there is duress or undue influence of a sort, for which reason a judgment is given, then that is not fair and that cannot be justice. And so and mind you, he was the head of all lawyers in this country, and he was the legal advisor to the government at the time. So if it could be established that indeed he had such an interaction, that would be a doom day again for the profession we all cherish, because then I don't know what kind of example the leader sought to give to the people of this country.
And now he's telling all of us, I mean, in a 50-page response that, I mean, listen, there's no any piece of evidence, I mean, adduced in the matter, either by prosecution or defense, I mean, which is alleged to be fabricated by him. I mean, in terms of what Richard Jakpa is saying. I mean, so what should Richard be doing? Now, Richard has to prove beyond doubt that there is enough evidence to prove that Odame did what he's accusing him of?
Of course, yes. The law is explicit that he who alleges must establish or must prove. Who he make an averment. It is not enough to make an averment in the vacuum, but an averment must be followed by evidence, and that is provided for by the Evidence Act. There is an obligation on any party who goes to court to bring sufficient evidence that is capable of swearing or capable of convincing the court that actually whatever averment you have made is true. Otherwise, you stand the chance to fail in your averment that you might have brought before the court. So under these circumstances, now the obligation, the duty is now imposed upon Richard Jakpa to bring evidence sufficient enough in order to show to court that actually he has done it. And once that is established, then there's nothing again. But otherwise, the law is there to protect both accused and also the complainant. And so that is why there is a high burden of proof that is placed on anyone who actually makes such an allegation. So now, where we stand now, it is over to Richard Jakpa to bring sufficient evidence to court or to the investigative body to show that actually Godfred Adame has actually done what he is alleging that he has done.
Because I'm not a lawyer. I'm not into the space, but looking at the way things are going, I mean, for Jakpa to say that he has enough to tell, I mean, that Adame seriously attempted to persuade him to testify. Yeah. I mean, in particular manner, so as to dishonestly and then wickedly and without an iota of conscience implicate Dr. Atto Forsen. I mean, you're a lawyer. Such matters, I mean, such areas of this, is it going to be very easy to prove this case?
He is saying such a thing has happened. And you see, as a lawyer, the first thing that comes to my mind is why, in the first place, a counsel on the opposite side should meet a witness in a matter that is involved.
Okay.
Right?
Okay.
That is very pertinent because it is not allowed.
Okay.
And in any case where you choose to meet a witness of the opposite side, you need to let the defense counsel to be aware. You need to let him also know that I am going. And sometimes it is even more important that you even meet that witness with the other lawyer. So that if there are certain things that you need to sort, it will be sorted with his lawyer. But to the extent of meeting, not to prejudice the matter before the investigative body, but as a lawyer, things are running in my mind. Why, in the first place, should he even contact the witness of the other party? Why?
Okay.
So, if there is anything at all to go by, that is where we should start it from. Now, why should he meet that witness? And if that why is answered, then we try to see whether or not it is justifiable under the circumstance to have met him. If not, then he should be found wanting.
Like your views on this, between petitioning the CID and petitioning maybe the bar, which one would have been much perfect to deal with this issue?
Well, for me, if it comes to the practice of the law, you will appreciate that things of this matter, it is within the ambit of the General Legal Counsel, where a lawyer misbehave or misconduct himself. General Legal Counsel is where you take him or her to, so that they will be able to sanction him accordingly. So sanctions such as even taking or revoking of license could be done for the person. Right. So, well, again, I don't know if there is more to it because I've not had the benefit of reading the petition, for which reason Richard Jakpa could also go to CID. But otherwise, for me as a lawyer, I know that where there is a misconduct on part of a lawyer, the best place to go is General Legal Counsel, because they actually regulate the practice of law in this country.
Lawyer, after going to court ended the case. We are back again to petition the CID. And then we are even looking at the General Legal Counsel being petitioned, or the conduct or the ethics and all that, the ethical, practices and all. If somebody says that Jakpa or Richard Jakpa is bathing in the soup or the river of witch hunting. Would you agree to that?
Normally, until a matter is even finished before the court, or until something happened, you cannot just go to General Legal Council. You can't petition them.
Okay.
So it is after the process that, and even at the time, I think Richard Jakpa was also before the court. So he was also trying, maybe, I am not speaking for him, I'm not his lawyer, but I think at the time he may be fighting for himself. Now that everything is dash and done, I think this is the time for him to also fight his cause.
So you wouldn't see
so
it
we
as
cannot
witch
label
hunting,
this
right?
as witch hunting. This cannot be as a witch hunting.
Okay.
Maybe in his opinion, he's trying to make sure that due processes are done and that a lawyer should not misconduct himself in any way, like he's alleging that Godfred Adame has done. Yeah.
Very well. Before you take leave of us, I mean, the issue of the Ashanti Regional Chairman of the New Patriotic Party, i.e. Bernard Nchubuesiakon Wontumi, Chairman, 1 million bail pending the commencement of a trial today. I'm sure you've heard it.
Yeah, I did hear that.
What's your view on that?
Oh, the grant of bail is actually discretionary.
Okay.
And anytime either investigative body or a court is granting bail, depending on the gravity of the accusation, they will actually seek for surety. And it is for the purposes of the fact that they want to, at all times, get him whenever they need him to appear before the investigative body or court. So for the bail conditions, it is by law that if the person has done something that is so grave, then you have to assure yourself that you tie him to something that will make him come back for the investigation to be continued. So under the circumstance, it is just fair to say that yes, it should bring some surety. As to whether that is exorbitant or not, like I said earlier on, it is at the discretion of the body. But in any way, the law also provides that if it is too exorbitant, you can at any point in time apply for variation of this bail condition. But I think he has met it. I don't know.
Yeah, he did. He
has
did.
met
I
that.
mean,
So
he met it, yeah.
I think there is no dispute about that. So he will come and then stand trial.
Okay.
And we see what the court will tell us at the end of the day.
The former Attorney General and his lawyers got the police CID 5 after 10. The letter inviting him was to the effect that you're supposed to report at 10. So when we got there, it took the police CID some time to commence the interrogation. At least took about 1.5 hours. But during the course of the interrogation, I can confirm that it was cordial. The former AG gave his side of the story. At the end of the day, the police granted self-recognizance bail, and he walked out of the CID office back to his home. And so there wasn't much with regard to how he was treated at the police CID. It was very cordial. However, I understand that while we were up there, some people who came around supporting the former AG were driven out of the place, the CID yard. I mean, that's part of their protocol. If that is it, then perhaps something might have happened, but I cannot speak to that. That is what I heard, that some people came in and were driven out. They had to wait at the gate until we finished the proceedings. So in all, things went properly. And then I cannot report of any major incident.
Okay. On the bill, were there any specific conditions attached to it? For example, if and when he is expected to return to the police CID?
Yes, the former Attorney General was granted self-recognizance bail, which simply means that he signed his own bail.
Okay.
For that matter, any time the CID will be in need of him, you have to report to the police CID. And so we are expecting the CID to get back to him when they need him.
We've also seen statements from the AG denying these allegations. Were there any formal charges preferred against him?
Actually, before we went to the police CID, we had read the complaint filed by Jakpa, and he was talking about fabrication of evidence. And so that was what he was questioned on. As to whether that offense will hold is something that I have my doubt. But let's leave it to the CID for them to do their investigation, because it's a matter that has been pronounced upon by a court of law. Just a first award during the Jakpa trial or the ambulance trial ruled on that matter. An issue was raised, and when it was raised, it was ruled upon by the judge. If you read that ruling, the judge made it clear that he had even listened to the case over 10 times. At no point in time did the former AG suggest to Jakpa that he should fabricate evidence to get Honorable Atufo convicted. And so the matter is settled. But he's reported it, so let's see what happens. But from what I see as the lawyer, I don't see any future in this particular matter.
Mm-hmm. Now, we also understand that you presented a detailed 50-point document to the police. How did the CID respond to these documents that you presented today?
Yeah, it is true. The former AG wrote his own statement, typed it out. So after the interrogation, he was asked to write his statement. Then he indicated that he had already typed out his statement, that he was referring to that statement, was going to rely on it. So the police took that one and attached it as part of his statement to the police. So they are now going to look at the statement. Perhaps if it's needed again, he'll be invited back by the CID.
I was at the CID headquarters today. I saw some persons wearing T-shirts branded "Do not," supporting the former Attorney General. Was this your doing, or this is just natural support from members of the public there to support the former Attorney General?
Actually, apart from the lawyers who accompanied the AG, which we all knew, we never knew of any other persons coming to support him. Until we got upstairs, they realized that some people had come downstairs and were wearing some T-shirts. I don't know who brought them there, and I think they came to solidarize with the former AG, but it wasn't the doing of the AG or any of us who went with him. They came, and as to who brought them there is another matter that I cannot speak to. But for the lawyers, over 70 accompanied the former AG to the police headquarters.
From what transpired today, do you expect that the engagement should bring this matter to a close?
Speaking for myself, as a lawyer, I will not see any need for the former AG to be called back to the police CID for further interrogation. As I speak for myself, I do not know the information that they have or the evidence that they have is contrary to what he presented today. And so when he's invited again, we'll go and respond to it.
All right. I'm grateful to you, Mr. Alfred Chiayabua, a former Deputy Attorney General, one of the lawyers for former Attorney General Godfred Yabua Damin.